Hello, everyone, and welcome back to another session on polity and constitution. I hope I am audible as well as visible. Great, audible and visible. Let us wait for others to join, and then we'll begin our discussion for the day. Okay, let's do a quick recap. In the meantime, others can keep on joining. So, in the previous class, that is yesterday, we had taken up for discussion center state relations, and we looked into the administrative relations, starting with Article 339, Clause 2, then 347 and 350A. The directions that the center gives, the president gives to the states. Then bodies like interstate council, the zonal councils, the northeastern council, then the financial relations, how we have seen that there are limitations on the state's power to impose taxes, right? Beyond that, we have also seen the issues in the financial relationship between center and states. Once we are done with this, we moved on to understanding fundamental rights, under which, firstly, Article 12, the definition of fundamental rights, then Article 13, which also brought to light the discussion on basic structure doctrine, how the conflict between Article 13, Clause 2 and Article 368 brought to the forefront this issue that there should be limitations on the powers of the parliament. In fact, it is in pursuance of Article 14, which we saw yesterday, the rule of law. What is that? Limitation on the powers of state. State's powers cannot be arbitrary. So we also saw that in the landmark Keshwan Bharti case of 1973, wherein the Supreme Court, with a 7:6 judgment, came up with a concept of basic structure, which can never be modified, can never be amended in the country. So these are the things we covered yesterday. The last point being Article 14, the criteria for reasonable classification. When you create groups and treat people differently, what are the two important parameters that you must keep in mind? The intelligible differentia, meaning when you create groups, always try to keep people in the group, people under similar circumstance in one group. And second was, there should be a link, a nexus between the classification exercise and the objective of the law. Okay, that's it with respect to our discussion. Now, we'll begin our discussion for today, starting with Article 15. But before that, of course, 5 questions for the day. First question, mark your answer, please. Okay, so clearly, lack of revision. Amazing. Ad hoc judges. Article 127, 128. Ad hoc judges, retired judges. The president does not appoint, the Chief Justice of India appoints ad hoc judges in consultation with the or with prior consent of the president. So A is incorrect, other statements are actually correct. Okay, so this is ad hoc judges, topic under Supreme Court. Moving on to the next question. Okay, a lot of you got this correct. There is no maximum period for financial emergency. Let me remind you, the maximum period is only for one type of emergency, that is president's rule, which is how many years? 3 years. Okay. Repeated parliamentary approval is required only for national emergency and president's rule, not for financial emergency. So this is also correct. We do not need approval every 6 months to continue a financial emergency. Both the statements are correct. Hence, C. Both 1 and 2. This was with reference to financial emergency, not president's rule. Okay. Nitesh, maximum period given na. Na. After 6 months, approval required na. Anyway, uh, it's okay. The statements are correct. Both of them are correct. Moving on to question number 3, the third question. Okay, fair enough. A lot of you got this correct. In which of the following situations the imposition of the president's rule would be improper? Incorrect. So there are only three situations where the president's rule is correct. One is secularism, if the state government works against secularism. Number two is Article 365, if the state disregards a constitutional direction of the center. And number three, if no government can be formed after the governor gives opportunity for the various parties to form the government, in the case of hung legislature, right? So those three are the only situations where we can properly impose president's rule. All other cases, I had mentioned this clearly, that if the CM is not working, there is maladministration, there is corruption allegation against him or her, this is not a ground for president's rule. So of course, these two are not grounds of president's rule. Improper grounds 1 and 2A. Clear? Moving on to the next question. Question number 4. Okay, a lot of you got this correct. Consider the following statements with reference to the constitutional provisions related to the seat of Supreme Court. This is Article 130. Supreme Court shall sit in Delhi or any other place is correct. The seat will be decided by the Chief Justice is correct. The approval of the President is required, not the Parliament, with respect to any changes. Can sit in any other place with the approval of the President. 3 is wrong. D, 1 and 2 only being the correct answer. Last question for today. States which have a TAC, Tribal Advisory Council. So, of course, all those 10 states, which include Andhra Pradesh and Rajasthan, then states like West Bengal, Uttarakhand, and Tamil Nadu. So this does not have a tribal advisory council. Okay, that's it. We are done with the 5 questions for the day. Let's move on now to Article 15. Show the leaderboard. 5 people getting all 5 correct. Himanshu, Janvi, Lucky, Kishan, and Shelly. Others: Siddharath, Chinmay, Beauty, Sachin, Shamil, Raj Arvind, Sat, Meera, Vikram, Ankush, Sejal, Navnita. Then you have others who are getting 3 correct. Today, not a good day for most of you. Getting 1 or 2 wrong at least, majority. And others, as usual, getting 2 or 1 correct or 3 correct. Great. Srimant, Rajasthan has tribal. Does Rajasthan have tribal? Then third will be, does Rajasthan have scheduled areas? Question mark. Ask in one, it's okay. Yes. Banswara, Pratapgarh, all those areas, I think those districts come under Schedule 5 areas. I had mentioned in the topic specifically that please remember the names of these 10 states. Of course, and when the question is here, it is very much clear it would have Schedule 5 areas. Anyway, it's okay. No problem. After all, we have to raise some concern, right? How many Supreme Courts are there in India? Yes, this is a question we expect towards the end of our polity discussions. Of course. 25? Guys, please. Are you just going to give me a heart attack or what? 25 Supreme Courts. Is it some joke? Then it's okay. Firstly, people are asking how many Supreme Courts, and then the response comes 25 Supreme Courts. Okay, okay, okay. Calm down. As the words of the great song go, I think I need to calm down a bit. Let's ignore 33, 24, some unique answers. We want more unique answers. Okay, let's move on now to Article 15. I'm sure you must have seen the movie Article 15, right? How many of you have seen Article 15? Tell me. It's okay. If you have not seen, you have missed nothing in life. Don't worry. Uh, Article 15 was based on this point that there should not be any discrimination in the country. Now, one very important, no, not of Bobby Deol, of Ayushman Khurrana. Some Bobby Deol fan in the house is there. No, sorry, Ayushman Khurrana is Article 15, not Bobby Deol. Uh, there are some fundamental rights. An important point to know: there are some fundamental rights which are available only to Indian citizens. Let's come back to the topic now. Only for citizens. So, citizens enjoy some special rights, special privilege, benefits, entitlements. These: Article 15, Article 16, Article 19, Article 29, and Article 30. These are the fundamental rights which are available only to citizens. Are we clear on this? Please repeat with me. 15, 16, 19, 29, and 30. Okay. Now coming to Article 15. Article 15 says the state shall not discriminate. The state will not discriminate against any, look at the phrase, citizen on grounds only of. Only of. What's the meaning of only of? Only means only these grounds. Meaning on other grounds, discrimination is allowed. So citizens will not face any discrimination on the grounds only of religion, race, caste, sex. Sex is gender, and place of birth. We call it RRCSP. So that you remember it. RRCSP. Religion, race, caste, sex, place of birth. On these grounds, no discrimination. Clear? So, this is with respect to Article 15. Now, as I said, on other grounds, is discrimination allowed? Yes. On other grounds, discrimination is allowed. For example, for example, age, yes or no? Educational qualifications, yes or no? For example, if you want to go to a place uh, to get a house on rent, let's say, and the person asks you, do you eat non-veg? And you say, yes, yes, 3 times a day, daily, 24/7. Then the person says, get lost immediately. What is that? That is discrimination on the basis of food habit. So, on these grounds, allowed. On the grounds of RRCSP, not allowed. Okay. Okay. I hope this point is clear. Everyone, yes, marriage status, financial status, all these things, residence, yes, it can be done, but not on these grounds. Now, one more thing. When we mention here, the state shall not discriminate on the grounds only of sex, gender, then how do we have all these government schools for girls only? Government schools for girls? Yes or no? So tomorrow start protesting. Don't go and protest. Okay? Because the same Article 15, Clause 3 allows for this. Nothing in this article shall prevent the state from making any special provision for women and children. So please don't go and start protesting. And if you do, please don't tell people that you have read polity from me. I don't want to be the person to be known that a faculty for students with half-baked information, right? So please, at your own risk. So nothing in this article shall prevent the state from making any special provision for women and children. So for women also we can have special provisions. For children also we can have special provisions. Classic example would be a government school for girls for boys, etc. Okay. Now, this clause 1 is for what? This clause 1 is for state to have a limitation. This clause 1 places a limitation on the state. State shall not discriminate. My point is, can others discriminate? No. Other people also cannot discriminate. Look at this. Second clause says that no citizen shall face any discrimination, any disability, any special liability, any restriction, or any condition on the grounds of religion, race, caste, sex, place of birth, with regard to access to shops, public restaurants, hotels, places of public entertainment, use of wells, tanks, bathing ghats, roads, places of public resort, all such things. So, not only can the state not discriminate, other people can also not discriminate against us, citizens, on the grounds of RRCSP. Religion, race, caste, sex, place of birth. Okay, that's it. So, a simple question here. If you are denied entry in any place because you are not dressed appropriately, let's say go to a pub, right? A club, dance floor, you want to dance, but the club says, sorry, get lost, you are not wearing shoes or you are wearing only shorts. Then, is it discrimination on Article 15? Tell me. Of course not. It does not discriminate. Why? Because on the basis of Article 15, because Article 15 only RRCSP. Okay. But if you go to a place, where you are denied entry based on your religion, then tell me, will that be discrimination on the grounds of Article 15? Yes, of course. So, only those 5 grounds. On other grounds, discrimination is allowed. Are we clear on this? So, this is meant for everybody. Private institutions, private people, non-citizens, etc. Even they cannot discriminate against us. So no citizen will face any kind of discrimination, either from a government organization or a private body or an individual on the grounds of RRCSP. Okay, so that is there. This means a very, very simple question. This is a true story. I usually ask this in the class. There was a case where in one city, a food chain, these kids who beg on the streets, these kids, they collected some money and they wanted to enter this food joint to purchase some pizza or burger, whatever. Now, this food joint, the manager there denied these kids entry. Is this violative of Article 15? Tell me. Don't write yes. Give me reasons. On what ground is this violating Article 15? See, race basically refers to your physical features, right? That, for example, color. Now, lot of people believe race to be a social construct. It's more dependent on your physical features, right? There is no set definition of race, but largely those physical features, which in USA you see color, it's a part of race only. Either caste or place of birth. How do you know the place of birth of those people? They're all born in India only. All those who said yes, denial in public restaurants should not take place on the grounds of religion, race, caste, sex, place of birth. The manager there did not know their religion, their caste, their place of birth, etc. Are we clear? Everybody. So this was not Surya again writing the same thing 5 times. I am telling you, please tell me the reason. You are telling me denial under this. I am telling you on what grounds you are saying under this. They were denied entry based on their possibly economic situation, possibly hygiene. We don't know, right? So, hmm, sir, yes, under access to shops. Who mentioned that? So, the example I gave right now, don't panic. The example I gave right now did not violate Article 15. Okay? Don't be emotional. Article 15 gets violated only if you are facing any discrimination on the grounds of RRCSP. That's it. Nothing else. Are we clear on this? This is the only ground of discrimination. Mohan, but sir, it is discrimination. So why it is not under Article 15? Huh? Guys, I'll repeat once again. Article 15 will get violated only on these grounds. On other grounds, discrimination is allowed. Does UPSC not discriminate based on age, based on educational qualifications? It discriminates, yes or no? Can we go to court and challenge this? Then they discriminate on the basis of marks. Go to court tomorrow and challenge how dare they discriminate. If what happened if I get only 5 marks in prelims? I want the right to sit in the main examination. Right? Let's do it. Don't do it. If you do it, please don't tell people that you studied polity from me. That's it. Keep it a secret. So, discrimination on other grounds are allowed. Okay. This is Article 15. Discrimination based on attire. Somebody, Sachin says, discrimination based on attire. Is it allowed? Please tell me, guys. Can we discriminate against somebody based on attire? No. Uh, the discrimination on the basis of attire, I mean, dressing sense, it is allowed. RRCSP not allowed. How many times? RRCSP. Okay. Legally, yes. Morally, no. Anyway, this is Article 15. Now, I think you have understood what is Article 15. The state or any person will not discriminate against us, Indian citizens, on the grounds of RRCSP. If the discrimination is on these grounds, very good. It will not be allowed. Go to court. If it is on other grounds, then sorry, you'll have to face the discrimination. For example, there are some PGs meant only for girls, meant only for boys. Should we start protesting now? How dare you? Based on gender. They will simply say, we are preventing your entry based on morality. When you go to court to file a case, the court will also scold you, saying, get lost immediately, or else I'll impose a fine. So please don't try all these things. You have to make sure that the discrimination is only on grounds of RRCSP. Only then can that be called a discrimination, a violation of Article 15. On all other grounds is allowed. Okay. Now don't worry. Some of you are saying that, but there is discrimination on the basis of caste in schools and colleges, right? We'll come to that also. Then some of you are mentioning uh, denial of temple entry, mosque discrimination of girls. Firstly, not all mosques do it. Dargah, yes, they do it. Just like the case of Sabrimala, they do it. But we'll discuss that separately. And anyway, that is with respect to what? With respect to a pending case in Supreme Court. This matter is already pending in Supreme Court. So let us end that story for now only. A 9-judge bench is going to hear a matter which is the denial of women in places of worship, whether it is for Hindus or Muslims, etc. Okay, so that is there. So we will not discuss that until and unless Supreme Court gives a judgment on that, and more on Sabrimala when we study Article 26. Okay, this was Article 15, but then some very important events in the country resulted in what? Resulted in us getting an understanding of what could have gone wrong in the country. For example, see, back in 1950s, late 1940s, in Madras province, present day Tamil Nadu, Madras province, there was a government order issued by the government there, which was known as the communal government order. Under this government order, seats were reserved in the engineering and medical colleges. 6 seats for non-Brahmins, uh, 2 seats for Brahmins, 2 seats for Muslims, etc. 2 seats for SCs, STs, 1 seat for Anglo-Indian, 1 seat for Indian Christians. Is in such manners, reservation was given based on caste as well as religion. Now, there was a lady, Champakam Durai Ranjan. She scored very good marks, but still could not get through the engineering examination, could not get selected because she belonged to the Brahmin community, and the 2 seats reserved for her community were already filled. Okay, she went to the Supreme Court. Supreme Court, please save me. Why? Because this kind of reservation violated one article 29 clause 2. What is this? No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds. on the grounds of religion, race, caste, or language. So, if there is any state based school or college, any school or college maintained or by the state or getting government funds, then we cannot deny people entry based on religion, based on race, based on caste, based on language. In this case, she was being denied entry based on her caste. Supreme Court said such kind of orders, rules, regulations which violate Part 3 cannot continue because Article 13, Clause 2 says that the state shall not make a law which violates fundamental rights. That is why the quotas in educational institutions was struck down by the Supreme Court because it violated Article 29, Clause 2. However, the Parliament immediately, by amending the constitution, added Article 15 Clause 4, which is the beginning of the reservation policy in educational institutions. With this, the Article 15 Clause 4 was inserted in the constitution, and it said that the state can make provisions for what? For scheduled castes, scheduled tribes, and SEBC. What is that? Socially and educationally backward classes. SEBC. Socially and educationally backward classes. For these groups, the state can provide for reservation in government schools or colleges. Government schools or colleges. Clear? This is the beginning of reservation in educational institutions. Clear? Socially and educationally backward classes, that is what you commonly know as OBC, other backward classes. Clear? This was done in 1951. Slowly and steadily, we came to realize that lot of these state governments started enforcing such reservations also in the government schools and colleges, non-government schools and colleges, meaning private schools and colleges. Now, this was wrong because the Supreme Court had clarified that you can impose reservation. The Parliament had clarified that you can impose reservation only in government schools and colleges, not in private schools and colleges. But some of the governments in the states started making mandatory reservation in private schools and colleges. Now, this was also challenged in the Supreme Court, in the PA Inamdar case, right? So, it said that there exists an Article 19 1G, which is what? All citizens have the right to practice any profession or to carry on any occupation, trade, or business. We call this POTB: profession, occupation, trade, business. Now, please tell me, if I have been given the fundamental right to run my own school, that is my business, that's my occupation, that's my trade, who is the government to interfere and tell me, please, mandatory 5 seats for SCs, 2 for STs, 3 for SEBCs? Who are you to tell me all this? Article 19 is a fundamental right I have. Okay. Also, it violates Article 14 because now you are treating a government school as well as a private school in a similar fashion. But a government school is different from a private school. Government schools are getting funds from government. A private school is being run by people on their own. How can you put them in the same group and enforce reservation on both such schools and colleges? So, Supreme Court cancelled all this quota in unaided. What is unaided? Unaided means which do not receive government funds. Do not receive state funds. So Supreme Court said that if you start getting money from the government school, reservation okay, but a private school, sorry, no reservation. Cancelled it. Why? Because it violated Article 14, it violated Article 19(1)(g). Again, the Parliament, to get around the Supreme Court judgment, modified the Constitution, added one more clause, Article 15, Clause 5, via the 93rd Amendment Act 2005, stating that, see, the state shall make special provisions for the SCs, STs, the socially and educationally backward classes in any school or college, in any educational institution. Look at this. It says whether aided or unaided, whether you get government funds or you are a private school. Clear? Only one exception is there. Other than minority educational institutions. So, those institutions which are meant for minorities, MEIs, those institutions run by minorities across the country, in them the state will not enforce reservation, but in all other schools and colleges the state can enforce reservation. Are we clear on this? There is no definition whatsoever of minorities. Let me clarify. Okay, here minority educational institutions, see, as far as the definition of minority is concerned, here a minority institution or college, right, is one which is established or maintained by people who are minorities. Here, minority is to be determined only by reference to the demography of a state and not at the whole country. Are we clear on this? Otherwise, religious minorities are on a country-wide basis, pan-India basis. But when it comes to minority educational institutions, which is governed through a law called a body called the National Commission for Minority Educational Institutions, and there is an act also. Under the law, minorities are decided on a state-wide basis. So let's say Hindus in Punjab, minority. Hindus in Nagaland, minority. Lakshadweep, minority. But Hindus in UP, not a minority. Are we clear on this? But this is only for educational institutions. There are over 13,000 minority educational institutions across the country. Okay? So, the Article 15 Clause 4 simply says that the state can provide for reservation in schools and government schools and colleges. Article 15 Clause 5 says the state can provide for reservation in government and private schools and colleges. Are we clear on this, everybody? Okay, any doubt? Any confusion? Okay, no confusion. Great. We are done with respect to Article 15. But, one small point. In 2019, this article was amended once more. One more clause was added. This time we added Article 15, Clause 6 was added. This said that the state will provide for reservation to economically weaker sections from the unreserved categories. So far, those groups which are not reserved, from those communities, the economically weaker sections will get some seats reserved. Now, who is to be a part of economically weaker section? That the central government will decide from time to time. Okay, on the basis of income, on the basis of land holding, etc. Clear, everybody? So currently, the annual family income limit is 8 lakh rupees. So if the family income is less than 8 lakh rupees, you are under the economically weaker section. You get the benefit of reservation based on economic parameters or criteria. Okay, that is it with respect to the what? Reservation in educational institutions. Somashri, how is Article 14 violated? Please pay attention once again. In this, Article 14 is violated. Let's understand this once again. The state was allowed through the First Amendment Act to make reservation in government schools and colleges. Suddenly, the state started making reservation in private schools and colleges run by people not getting government funds. So, the people went to court saying that you have put the private schools and government schools in the same category. You are treating us as one group. This is wrong. The test for reasonable classification, intelligible differentia, only people under similar circumstance should be grouped together. How can you keep a government school and a private school in the same group? They are two different types of schools. So, Article 14 was violated. Are we clear? This is the reason for violation of Article 14. Now you can look at the live video recording any number of times and enjoy. Okay, clear? Madhur, as I said just few minutes ago, maybe you are not paying attention, that any question on temple entry is best left for Article 26. When the time comes, I'll tell you. But in the meantime, you can keep your emotions under check by this very simple fact that denial of temple entry, this matter, not just temple entry, denial of entry of women in place of worship is a matter pending before a 9-judge bench of Supreme Court. Okay? So we'll wait for the 9-judge bench. Yes, Article 29 is still valid now, but there is an exception that despite being Article 29 being there, the state can provide for reservation in schools and colleges. Okay? That's it. We are done with Article 15. Now, coming to Article 16. See, Article 15 is something most of you have crossed. School, college, most of you. Though I'm sure there are some of you here who are in their schools only, of course. But a lot of you have crossed the school. How many of you are in your schools only, please tell me? Just write school and send a message. How many of you are still in school? 8th, 9th, 10th, 11th, 12th, till class 12th. I simply asked one thing. Just write school and send a text. But some people found it difficult and confusing. Okay, got it. Now, so a few of you only. Mostly people are, I believe, then in their graduation, etc., or they have cleared graduation. So we are talking to people who are more mature. Is the understanding in general? May not be the case always. So Article 16 is what affects you more, is what impacts you more. So Article 16 is the reservation in government jobs. So what is Article 16 firstly? Article 16 says there will be equality of opportunity in public employment. What is public employment? Employment, government jobs. Government jobs. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. In government jobs, equality of opportunity. Also, the article says no discrimination against any citizen. Why citizen? Because some fundamental rights are available only to citizens. Which five rights? Please repeat again with me. Wake up from the sleep. 15, 16, 19, 29, and 30. These five rights available only to citizens. So, the state shall not discriminate in matters of employment or office under the state on the grounds only of religion, race, caste, sex, place of birth. RRCSP. Two new grounds. One is descent, the other is residence. Descent. Descent means hereditary succession. Your origin, your nationality originally, your background, the background of your family is called descent. Descent is defined as hereditary succession. So, the state will not discriminate even if, let's say, you are an Anglo Indian. So, maybe your ancestry is of European descent. This does not mean that the state will start discriminating against you in government jobs. If you are an Indian citizen now, all public posts are open to you. Clear? And residence, domicile. Residence is the reference to domicile. Can you observe one very important point here? This residence is not a criteria in Article 15. Yes or no? Article 15 only says place of birth, not residence. That is why in your schools and colleges, you will find that in colleges, especially in the entry, say these IITs, NITs, etc., in various colleges, seats are reserved for states. Rajasthan, 5 seats. Tripura, 1 seat. Tamil Nadu, 8 seats. Bihar, 12 seats. Have you observed this? Quota for every state is there in schools and colleges, not for government jobs. So, in educational institutions, the state can discriminate on the basis of your domicile, but in government jobs, it is not there. Clear the difference? Anyway, one more point. I would like to tell you is this idea of residence based reservation. You must have observed that we have seen lot of states trying to make laws based on residence, domicile. Now, what happens is actually residence can be a ground of discrimination. Yes, it can. Even though it is mentioned here, residence can be a ground of discrimination, but the states cannot make a law. The parliament can make a law. Parliament can make a law and can provide for reservation based on residence. It can be done, but by the parliament, not the states. There are various such articles in the Indian constitution which have allowed reservation based on state. So, any kind of residence based reservation which is made by states is ultra vires the constitution. Supreme Court has said in the Pradeep Jain case, 1984, that residence based reservation is ultra vires the constitution. Okay, what is ultra vires? Tell me. In the chapter governor, we had come across this word ultra vires. Ultra vires means outside the scope of, beyond the scope of. Don't create your own meaning. This is the meaning of ultra vires. Okay. Then if this is Supreme Court stand and Supreme Court keeps on cancelling, lot of states try to make reservation policies for their locals, it always gets cancelled. Whether it was say in the state of Karnataka, whether in Maharashtra, whether in Gujarat, whether in MP, whether in Andhra Pradesh, we saw that whenever the state governments tried to make any kind of reservation for locals, it was cancelled by Supreme Court. But you will still find that in some states there is reservation. That is under the specific articles that are there. And other states try to get around this. How? So, states use language as a criteria. Now, if West Bengal says for all the Group C and Group D jobs, an additional paper in Bengali. Now, if you are from Kerala, why would you have any interest in knowing Bengali? Clear? You can't appear for the examination. Or somebody from Nagaland comes and sits for the Tamil Nadu local examinations. Here you will have additional paper in Tamil. Now, how will the Naga person know Tamil? So the state governments try to provide reservation to their people by using language. To provide benefits to locals, because language can be a criteria for discrimination. Okay, that's there. Article 16, Clause 1, Clause 2, Clause 3. Clear, everyone? So the state will ideally not discriminate on the grounds of RRCSP, descent, and residence in matters of public employment. Now let's come to this article 16 clause 4. Now, when you look at article 15, which is the article now to provide for reservation in schools and colleges, this concept of reservation in schools and colleges was not originally a part of what? The constitution. It was added later on. Yes or no? Tell me. The provision of education reservation was not originally a part of the Indian constitution. It was added later on. But this Article 16, Clause 4, which I'll explain right now, was originally a part of the Indian Constitution. It was not some later addition. The makers of this Constitution added this provision. This is not done through an amendment. What is that? This is Article 16, Clause 4. This is the article which provides for reservation in public employment. So, if you are asked which article says so, Article 16, Clause 4 says or talks about reservation in government jobs. It says state can make reservations in favor of backward classes without defining backward classes if they are not adequately represented in government jobs. In the opinion of the state, if some community is inadequately represented in government jobs, of course, then reservation can be provided for those communities. Reservation can be provided. Reservation, or call it affirmative action, or call it quotas, call it special provisions, call it anything. The point is all the same. Okay? Now, this concept of reservation that came in our country has come through the idea uh, put forward by Dr. Ambedkar. So, there were two approaches to deal with the problem of caste divide or bias in the country. One such approach was known as the Gandhian approach. So, Gandhiji did not believe in having a reservation policy. Gandhiji did not believe in having a reservation policy. Gandhiji believed in change of heart strategy. He was a great being. Change of heart. Need to provide reservation. The upper caste communities have been committing atrocities. Okay, agreed. But eventually, these upper caste communities will realize will realize that they have been suppressing the so-called lower caste communities for generations. Finally, they will realize their mistakes and they will have a change of heart, right? And once there is a change of heart, the upper caste communities will themselves give opportunities to the lower caste communities. So, don't worry, let there be a change of heart in the minds, in the hearts of amongst the upper caste people, and then you will no longer face atrocities. So, this was a Gandhian approach. Change of heart. There is a second approach, a secular approach. So, Ambedkar's approach. Ambedkar said we need not rely on somebody's goodwill. We have to go for a more secular approach, meaning we need to add statutory provisions for reservation. And that is why Article 16, Clause 4 was added in the Indian Constitution. Okay, this is what is called a secular approach. It is independent of any community's belief, any community's understanding, bias, etc. There is a provision in the Constitution, a legal provision, and we follow it. Clear? That is how it is called secular. So this is with respect to the two approaches. We have chosen, thankfully, the Ambedkar's approach, where we have provisions in the Constitution under Article 16, Clause 4 for reservation or affirmative action or quota or special provisions, whatever name you may call it, it's all the same. Clear? Now, let me also clarify one more thing. Lot of you here would have some opinion on reservation. Now, I don't want to undermine your opinion. You are entitled to your opinion, of course, whether right or wrong. That's the beauty nowadays, that everybody says it's my opinion. No, sometimes opinions are wrong also, but it's okay. I respect that. No problem. Uh, but the point is that I would prefer if you keep your opinion, if it is too extreme, to yourself. Okay. So some of you may have a very positive bias in favor of reservation. Others may be against it, right? Uh, you are an aspirant right now. You are embroiled in this topic of reservation. Some of you are getting a benefit. Some of you are not getting a benefit. Those getting benefit would be in favor of it. Those not getting benefit are against it. So as of now, it is slightly difficult for you to view this topic, from a neutral perspective. Okay. So please understand that also. You are a human being after all, and this may not be a topic wherein you should become extremely vocal. Here at least, maintain the decency, and please come off as an educated person truly, and also respect every person's view and their way of life. Okay. Now, I'll explain again what is the Gandhian approach. See, the point with reservation and such things is these things I explained are already available. I get the sense every now and then that some of you don't really listen to what I say. You are busy sleeping, roaming around here and there, and when you come back in front of screen, just shoot a question, because after all, I have paid for the product. Till you feel you are a customer, you'll always be a customer. Please be an aspirant, a student. So follow the class sincerely. And for those people, my request is you have the live video recordings available. Please watch, because most people are being very sincere in the class. I just see a few people who keep on doing this nonsense. I don't want to name them. What's the point? Maybe you want to get some attention, etc. But anyway, let's not waste time. I'll repeat this once again, and then I won't repeat it. Please watch the live recording. Gandhian approach is based on the change of heart. Gandhiji said there is no need to make any policy on reservation. What is reservation? Providing benefit to certain categories of people. Why? Because they have been suffering at the hands of higher castes. Okay. But Gandhiji says, I believe that in future, these people who are so-called upper caste people will slowly and steadily realize that they have been suppressing the lower caste people for generations. And once they realize their mistakes, they themselves will help their lower caste brothers and sisters to come up in life. So this was based on the belief that the person who is an oppressor will realize his mistakes. You give power to people and tell them now give up power. This never happens. Okay? This never happens. Once you get power, you will never give up power. So Gandhi's approach was very high funda approach. Normal mere mortals and human beings cannot follow all these things. Gandhiji was a great person. Always remember, don't criticize Gandhiji. Supreme Court has said under Article 19 that criticizing the great leaders of the country is not freedom of speech and expression. Are we clear? So, in case you want to go to court, etc., and jail, do it. Otherwise, don't criticize. Be respectful. You may differ with their opinion, but don't use harsh terms. Okay. So, we followed Ambedkar's approach of adding proper provisions in the constitution. Clear? Now, what is this reservation? So, this is the current reservation matrix at the central level. We have reservation for scheduled caste people, 15%, scheduled tribe people, 7.5%. This is based on their percentage in the total population. Then socially and educationally backward classes. This is what we refer to as OBCs, but now OBCs is meant for common people, noobs, beginners. You are legends now, right? So please use what? SEBC, socially and educationally backward classes. Then economically weaker sections, 10%, and for persons with disabilities, 4%. Now, within the persons with disabilities, you have horizontal reservation. 1% for people who are visually challenged, 1% for people with locomotor, movement disability, etc. That's also there. Now, we also should know what exactly is the criteria to identify scheduled caste people. What's the criteria to identify scheduled tribes people? And what's the criteria for SEBC, the socially and educationally backward classes? First up, scheduled caste. Now, the scheduled castes in the country through Article 341. Article 341 talks about the scheduled caste community. Okay. Now, the president will publish the list of names of all the scheduled castes, and this list is called Constitution Scheduled Caste Order. Constitution Scheduled Caste Order 1950. This is the list. State wise, you will find the names of all the scheduled caste communities in the country. Any modification is made by the parliament. Parliament makes modifications. Okay, so if you want to add a name of any community in the scheduled caste category, please send to parliament. Parliament will make a change. You cannot make a change. State governments cannot make a change. Now, scheduled caste communities belong to only certain communities. Only Hindus, and Sikh. Hindus, Buddhists, and Sikh. A scheduled caste person cannot be a Muslim. A scheduled caste person cannot be a Christian. A scheduled caste person cannot be a Jew, etc. Are we clear? You can belong to only these three communities. Cannot be a Jain also. Are we clear, everybody? Now, why are scheduled caste people from these communities only? Indic religions. Because the concept of scheduled caste is an Indic concept. Now, what is the criteria to identify that somebody belongs to a scheduled caste community? This criteria is a twofold criteria. Number one is untouchability. Untouchability via touch or even proximity. I'll explain that, don't worry. Second is denial of temple entry. This is the criteria. And what is a reason for providing reservation to scheduled caste committees? The reason is historical injustice. Now, this criteria has its origin. How did this criteria originate? This criteria originated in the report published by John Henry Hutton. So there was a committee called Hutton Committee. This Hutton Committee of 1931, though the report was published in 1933, called the Hutton Committee Report. This was a caste census conducted by the then Census Commissioner John Henry Hutton. So, John Henry Hutton was the Census Commissioner from 1929 to 33. And this report came. In 31, the committee was formed. In 33, they published the report. Did you understand this? Okay. If not, I don't know how you'll understand this. Now, just to point this out, I am sure you know this, that there are four Varnas: Brahmins, Kshatriya, Vaishya, and Shudra. The four Varna system or Varna system. Okay. Hutton Committee's task was to arrange all these communities in some list. How many Brahmins? What names do they have? How many Kshatriyas? What names do they have? Etc. He found that there were some communities which were outside the Varna system. He referred to them as the exterior caste or the depressed classes. Now, there was no common name for them. So he put them in a schedule. What is schedule? A list. Like we have schedule 1, 2, 3, 4 list. That is how they came with the name scheduled caste. List of all those communities with no common name. Okay. Then this was the exterior caste. Now, how did he arrive at these people? He found that these people had been facing two different kinds of atrocities. One was untouchability, that the so-called upper Varna people, upper caste committees did not even touch them. And also the upper Varna people, in some cases, did not go close to them also. Proximity, meaning if the upper caste person touches this person, he gets polluted. He or she has to take bath again. In some cases, it was found that not just touch, just mere proximity. If you are near some person like this, who is from a certain community, you get polluted. Based on this kind of atrocity, he clubbed them, and that is the source. Even till date, that's the source we use. Then there are certain communities which were denied entry in the temples. Okay. Now, there have been various such atrocities committed. I am sure you are aware of such things. For example, there were a lot of communities across the country where the people had to tie a broom around their waist when they walked. Because when they walked, the ground was getting polluted. So the broom around their waist was meant to supposedly clean the road as they walked. Sometimes, in some places, it was found that these people had to carry a pot around their neck. Why? Because his saliva fell from their mouth on the road. And what if an upper one person would walk on that? He would get polluted. So the saliva should fall in the pot only. Then, in lot of cases, these people were not allowed to enter the village because if somebody sees them, gets polluted. A very infamous case is of Purada Vannans. Purada Vannans in the Tinnevali district. Tinnevali, as the Britishers called it, it's now Tirunelveli in the in Tamil Nadu. So Tinnevali, or it was pronounced as Tinne Valley by the Britishers. So in Tinne Valley or district, there used to live a community called Purada Vannans. Now this community was not allowed to come out during daytime. Why? Because their sight was sufficient to cause pollution. If an upper world person saw them, he would get polluted. So these people were forced into living inside their houses or caves outside the villages for generations and generations. So the Hindu newspaper wrote an article on this, I think on the 24th of December 1932, which Ambedkar actually quoted in his speeches, that these communities leave their dens at dark and scuttle back home, run back home at the dawn like a badger rodent for generations. And no other, so Ambedkar said that no other civilization can be guilty of a greater cruelty than this. Then there was this case of Mulakkaram. So people from Kerala would know the legend of Nanjali. So there is this now there are lot of different opinions that in the princely state of Travancore there used to exist a tax called Mulakkaram. That tax was a breast tax. The women of the lower one, the scheduled caste communities or the depressed classes or the outside one system people, the women were not allowed to cover their breasts if they did not pay a tax. So to cover your body, you had to pay tax. Only those communities. That is where a legend of Nanjali is there, that when the king's men came to collect taxes, she chopped off her breasts and then passed away. That could be a story or legend, but this was a kind of tax. Now, of course, modern day historians, some of the more right wing historians deny this, like Manu S. Pillai, he says nothing called breast tax. Yes, there was a tax, but not a breast tax. An oppressive tax regime existed. Uh, the point is that we may never know what was the extent of reality on this. That's there. But of course, there would be some iota of truth. We cannot totally believe in the Marxist historians, of course, because nobody in this country has caused more harm to the country's culture and consciousness than these so-called Marxist historians, left-wingers. But this does not mean that all the right-wing historians are correct. Extreme point of view will never be correct. Anyway, now how did this concept originate? So, origin of this concept also comes from the marriage system. So, we had the upper Varn people and the lower Varn people. Boy, girl, boy, girl. Now, marriage between upper Varn people was allowed. But if a boy of upper Varn marries a girl of lower Varn, this kind of marriage was okay. It was called Anulom marriage. But if a boy of upper Varn if a boy of lower Varn married a girl of upper Varn, this kind of marriage was not allowed, called Pratilom marriage. Not allowed. So, the society, to prevent such marriages, if any such marriages took place, they would socially outcast, boycott those people, the couple, throw them out of the village, right? And those communities increased their kids known as chandals, and that is the origin of untouchability in the marriage system. Okay, that is how the concept of untouchability started. The limits of it defined by people based on various places, etc. These things keep on varying. This kind of atrocity has been faced by these communities for over 2000 years. That is why the reason for providing reservation to the scheduled castes is never the economic criteria, because even if you modify their economic situation, we have found that there is not much change in their perception in society in general, right? Just a few years back, there was a study conducted by NCAER, National Council for Applied Economic Research. The Indian Human Development Survey was conducted to look into whether untouchability still exists or not. So, two questions were asked. Will you or someone in your family let a scheduled caste person enter your kitchen? And number two, use your utensils. You'll be surprised that in 52% cases, when the Brahmins were asked this question, the answer was no. Either I will not allow or somebody in my family will not allow this. Amongst Hindus, it was overall 30%, but Jains was the highest, 35%. Even Sikh had it, 23%. Surprisingly, people like Muslims also had it. Christians also had it. So we very well saw an existence of this very unique form of untouchability. Even till now, see now what happens, untouchability does exist. The forms have changed, and the mindset still remains the same. Look at all the Group D employees. All the Group D employees, overwhelming majority of them are scheduled caste people. Secondly, manual scavengers, 99% of them are scheduled caste people, remaining, say, some tribal communities. And a lot also can be visible from how the society reacts to certain situations. For example, You know, 4 years back, 2019, this Social Attitudes Research India conducted a survey. It asked a question: should there be a law preventing high caste people and low caste people from marrying each other? Okay, you'll be surprised that in a city like Bombay, Mumbai, 27% men said yes, there should be a law which should prevent intercaste marriages. 40% of the adult population in Delhi said yes, there should be a law. 60% rural population of Rajasthan said yes, there should be a law. We still practice this. And if anybody here believes that no, there is no caste system, I would just ask you, please read the Sunday matrimonial page. You'll get to know the reality in the country. I think in some of your houses, in some form or the other, it is being practiced. The point is that they are our parents, so we ignore them. It's okay, no problem. How cute, how sweet. But the person facing that does not find it cute and sweet if our grandfathers and grandmothers are practicing it, right? We have to take into account the social realities and undo centuries of discrimination and prejudices suffered by the scheduled castes and scheduled tribes. I'll give you a better example. Back in 1990s or even 2005, when the reservation, so in 1990s, we'll see that shortly, the Mandal case, when the reservation for OBCs was brought for the first time, the SCBCs, a lot of these students who were graduates, etc., they came to Delhi to protest. And how were they protesting? They took a broom in their hand and, as a mark of protest, started sweeping the streets. Why? Because if you give our jobs to these people, then we'll have to do their jobs. In 2005, when the reservation in IIT IMs came into picture, same thing. All these parents took their kids to Delhi, Connaught Place, made them sit with a shoe brush, shoe polish, and photograph them. Why? If our kids or if their kids go to those colleges, then our kids will have to perform their kids' job. This shows your mentality. A lot can be found out through the type of protests which are there in the society, right? So these have existed. Even till date, people are going to face, people are still facing all these things, these sarcastic comments, etc. And the biggest point here is a lot of people say merit criteria. Nothing is merit criteria. It's all assisted merit. Assisted through your parents' situation, through their education, through their money, through their respect in society. And I think this was a right statement made by D.Y. Chandrachud, where he said that if the benchmark of efficiency is grounded in exclusion, then the result is only going to be a pattern of governance which will be skewed against the marginalized sections of the society. And that has been sadly the case, right? So, this is schedule caste. This is how we identify. This is the criteria, parameter, etc. for the scheduled caste communities. Number one. As far as scheduled tribes are concerned, it's very simple. Nothing much to discuss here. For scheduled tribes, now scheduled tribes are religion neutral. Okay, scheduled tribes can belong to any religion. Religion neutral. This is mentioned under Article 342. Same thing. The president will publish the list. The list is called Constitution Scheduled Tribes Order, again of 1950, though in some places you may find this list to be a list of 1958 also, but it is because in 1958 the list was finalized, and here also it is the parliament which makes modifications. Now, what's the criteria? The criteria is two criteria. Communities which are isolated, communities which are vulnerable, and this is identification is done, this is identified based on recommendations from Anthropological Survey of India. Okay, that's it. Third is the SEBC, socially and educationally backward classes. Or popularly referred to as the other backward classes, OBCs. Now, here their reference is under Article 342 capital A. Okay. And interestingly, for the SEBCs, the president will consult the governor also. So, we have different lists for the center and for the states. So you may be an SEBC in your state, may not be an SEBC at the central level. You may be an SEBC at the central level, may not be an SEBC in your state. That's possible. Okay, but that's not the case for scheduled caste committees. Now, what is the criteria here? There are fourfold criteria. Number one, low social position. So communities which are also very small in number, backward, economically backward, and small in number. If you are small in number, then you also lose the bargaining power during elections. So low social position. Then lack of general educational advancements. Number three, inadequate or no representation in government service. Inadequate representation in government service, and inadequate representation in trade, commerce, and industry. Okay, this is a criteria for SEBCs. So we have the scheduled castes, scheduled tribes, and the socially and educationally backward classes with the criteria as I have explained right now. Are we clear on this? Shudras are not scheduled caste people. Can you understand this point here? Shudras were not a part of exterior caste. Okay. These words have not been defined anywhere. Okay. It will depend on the concerned government that they have to prove the criteria through facts. Okay. Inadequate means insufficient. No Shamil, not at all. Yes, Gyanendra, OBCs. Yes, Dhyana, Dalits are scheduled castes. Himanshu, Article 16 Clause 4 does not violate 16.1 because 16 Clause 4 says that nothing in Article 16 shall prevent the state. So, when you make such statements, trying to compare two articles, it is very important to read those two articles before making an assessment. Half-baked knowledge is very dangerous. The choice of words are very, very clear in the Constitution, right? So, only rarely are mistakes made, and there also cases have taken place and things have been rectified or interpreted. So, under Article 16, Clause 4, it is very clearly mentioned nothing in this Article 16 shall prevent the state from making special provisions or providing for reservation in government jobs. If the state feels that some communities are inadequately represented, then they can make special provisions. Okay. Shamil, Articles 341, 342, that consultation with the governors is not binding on the president. But 342A, the states have been left for to make a law on their own, or to have a list of their own, which is different from that for SCs and STs, right? So for SC STs, we have one common list only across the country. Yes, in that list, the committees are based on state to state basis. But for SEBCs, there the state governments are allowed to have their own list of SEBCs. Shreyank, yes, I know what you're trying to say. Conversions have happened for all the tribals. That is true. Now, what can be done if somebody wants to convert? Then what do we do now? Right? Okay. Let's take a break. Surya, might I will tell you currently some of the missionaries, communities, groups have filed petitions in the court demanding the scheduled caste status be made religion neutral. Why? Because as of now, lot of people convert to Christianity, tribal especially, and there is no change or no effect on their situation in terms of getting benefits from the government. But if you are a scheduled caste person and you leave the Hindu fold or the Sikh fold or the Buddhist fold and move to Islam or largely Christianity, you lose your benefits from the government as a scheduled caste person. Are you clear? So, the point here is that the communities are facing, the missionaries are facing a problem because lot of the scheduled caste people don't want to convert to Christianity because they may lose the benefits. That is why this petition has been filed. Otherwise, there is no reason whatsoever for any community to keep on claiming that. And the petitions are in fact improper, because the idea is that this abhorrent practice of untouchability was an Indic practice. So, if I am a scheduled caste person facing this atrocity, I leave my caste, religion, and I move to, say, a religion which is all encompassing, then I should ideally not be facing these atrocities. So, the logic there is flawed to file a petition. Let's see what the court says. Converted tribals are scheduled tribes, converted scheduled caste people. If they leave the Hindu, Buddhist, or Sikh fold, they lose the SC status. Done? That's it. Let's take a break. After the break, we'll come back and we'll discuss a very, very important point, that is the Supreme Court's judgment in the Mandal case or the Indira Sahni case, which provides for comprehensive understanding of Article 16. Let's take a break. Be back at 8:05 and we'll take our discussion further on the Backward Classes Commission. Break, please. Let's continue, guys. Okay, now coming to the Backward Classes Commission. So, back in 1950s, when I say 1950s, to be exact, 1953, the 29th of January, a commission was set up called Kaka, or the first Backward Classes Commission under the chairmanship of Kaka Kalelkar. The first Backward Classes Commission was set up in 1953, which gave its report in 1955. And the chairperson was Kaka Kalelkar. This commission was set up to look into the conditions of backward classes and find out if they merit any kind of affirmative action or reservation or quota in government jobs or not. Now, this commission did give a recommendation like this. It actually said that the backward classes, they should be given almost 75% reservation. Now, that was a bit too high, and hence the commission's recommendations were never accepted largely. But then once post emergency, Janta Party came to power. Now, when Janta Party came to power, it set up a commission under the chairmanship of the former Bihar Chief Minister BP Mandal, called the Mandal Commission. This commission was set up in 1979, the second Backward Classes Commission, to look into whether any kind of possibility exists or not to provide reservation for the backward classes. And this Mandal Commission, or the first or second Backward Classes Commission, said that yes, the socially and educationally backward classes can be given reservation up to 27% in government jobs. Now, this commission's recommendations could not be accepted because the Janta Party collapsed, the coalition collapsed, and Congress came to power. But in 1989, when Rajiv Gandhi government lost, a national front government was formed. The VP Singh government gave the notification, right? Gave the notification to provide for reservation for 27% people in the government jobs. Why 27%? Because in 1964, in the Bharat Shah case, Supreme Court had said reservations should be limited to maximum 50%. Hence, the reservation for the OBCs at 27% only. Let me clarify, OBCs, according to most estimates in the country, are more than 50%, right? More than 50%, around 55% is with respect to the total population are OBC. So, still, if you look at in that sense, they are still underrepresented. This is BP Mandal, BP Mandal. Now, this reservation was, of course, challenged. Of course, challenged in the very famous case, the Indra Sahni case. or also called the Mandal case of 1992. Supreme Court upheld the 27% reservation but gave 5 conditions. Condition number 1, and lastly the most misunderstood condition, right, is the condition that quota should not cross 50%. Now, in 1963, I mean, the judgment date, publishing date is 64, but you can say 63, no problem. In 1963, the Supreme Court had said that quota should not cross 50%. In the Indira Sani case, also Supreme Court said that the reservation should be less than 50% seats. However, the court also said that if it is more than 50%, then it will be subject to review. Are we clear on this? The moment it is not that the quotas cannot cross 50%, misconception, the quota can cross 50%. But if you make reservations for seats more than 50%, then the Supreme Court can review it. So it is subject to judicial review. Clear? Now, second point. For the SEBCs, there are multiple criteria. One such criteria is that some of the committees are very small in population. Other criteria is that the committee can be in very huge population but are educationally backward, or they are not there in government jobs. So economic parameter comes into picture for SEBCs. Their low position is largely low economic and educational status also. So if you improve their status, they may stop facing the same kind of backwardness. Clear? So the Supreme Court said exclude the creamy layer. Who are creamy layer? The elite people. We had discussed this word earlier also under Panchayat. Socially advanced groups are called creamy layer. So for that, a committee was set up, retired Justice Ram Nandan Prasad Committee. RN Prasad Committee was set up of 1993 was set up. This committee gave a recommendation on what can be a parameter, criteria to exclude some people who belong to the other backward classes from getting the benefits because they are socially, educationally, economically advanced communities. Okay, so this committee gave the creamy layer criteria. The creamy layer in a particular group, some people are rich, socially, economically, educationally advanced people. This is the creamy layer criteria. These people, their kids, will be exempted from the quota benefit. People holding the constitutional post, if your father, mother is a president of India, VP of India, judge of Supreme Court, etc., of course you don't get the benefit. Or Group A, Group B services, persons in the armed forces at top ranks, persons employed as doctors, lawyers, etc., people in trade, business, industry, people holding agricultural income above a certain limit, or people holding certain land in urban areas above a certain limit, and lastly, people having gross income more than 8 lakhs. So we started our this journey of 8 lakhs with 1 lakh only. Originally, this criteria was just 1 lakh. When the Ram Nandan Committee in 1993 gave the recommendation, the criteria was just 1 lakh. We slowly and steadily have increased the criteria. So in 2004, it was increased to 2.5 lakhs. Then in 2008 to 4.5 lakhs. Then in 2013 to 6 lakhs. And then finally in 2017 to 8 lakhs. So largely this criteria of 8 lakhs as a convention, as a practice, it is revised every 5 years. But because of pandemic, it could not be revised. Though some people are saying that let's have the criteria at 12 lakh rupees. 12 lakh rupees per annum, and we will call you what? Economically weaker section. Why 12 lakhs? Make it 1 crore only. Call everybody poor. In India, 12 lakhs, if you're earning 12 lakhs, you are called economically weaker. By what standards? I mean, this is sometimes our MPs and some people are claiming make it 15 lakh rupees. They'll make any kind of demand. And the real poor is suffering. Same goes for the EWS also. Look at the current situation. You are earning 8 lakh rupees and you claim I am a poor person in India. That is why in the EWS category also, most people who are beneficiaries are the ones who are in the better income group. And we also know very well how people get their income certificates. Let's not get into that as well. Because if that was not the case, I'll tell you an example. From 2015 to 2019, there have been 63 cases where the candidates who have qualified in UPSC, they were not appointed because they failed to provide the genuineness of the certificate of their non-creamy layer. Yes, Nitesh, 8 lakh is per annum. 8 lakhs per annum is more than 50,000 per month of salary. Even if you remove all the taxes, you have no savings, etc. In our country, that cannot be called as poor. Maybe in USA or UK. In India, in most part of the country, that cannot be referred to as a weaker section, frankly. 8 lakhs is annual income. It's mentioned here, gross annual income. Vivek, come on. I think just a few moments ago you asked a question, mutton committee or hutton committee. Is it for fun that you ask, or are these genuine concerns that you have? Concept of creamy layer is applicable only to SEBCs. Yes, creamy layer criteria is not applicable to scheduled castes and scheduled tribes. Okay, number 3. Supreme Court also said that, see, the OBC community and categorizing them could be misused by the governments. So whenever you find out or you try to classify a category as a OBC, SEBC category, then judiciary can review it whether that community or category actually is an SEBC category or not. So whenever the government tries to categorize some community under SEBC, like Marathas, OBC reservation, Supreme Court cancelled it. So Supreme Court said we'll check it, whether they are actually backward or not. We'll ask the government to give us data, proof, right? Then Article 16 Clause 4. What is this article? 16 Clause 4. This article refers to reservation in government jobs. This article is reservation. Supreme Court said that whenever you provide for reservation, you also have to focus on Article 335. Now, what is Article 335? Look at this. Don't read the second paragraph, read the first paragraph only. The claims of the members of scheduled castes and the scheduled tribes, it will be taken into consideration consistently with the maintenance of efficiency of administration. Meaning, whenever you are providing reservation to SC/ST, don't provide it to any random person. The efficiency of administration cannot be compromised. Are we clear on this? The efficiency of administration cannot be compromised. That was Supreme Court's statement. That yes, provide reservation without compromising on efficiency of administration. Sadly, there is no way to measure the efficiency of administration. There is no definition how to measure it. Anyway, the parliament, after a few years, amended this article and added a provision below it. What was that? This was added via the 82nd Amendment Act of the year 2000. In this, the court said, the parliament said that forget what we mentioned here. Nothing in this article shall prevent the state from making any provision in the favor of SCs or STs, whether relaxation in qualifying marks or lowering the standards of evaluation. Whether we have to relax the qualifying marks, different cutoff marks, or we have to lower the evaluation standards, we will do it. Our primary purpose is to provide for reservation. Whether for that we have to have different cutoff marks or whether we have to have different parameters of evaluation, we will do all that. Are we clear on this? So I hope you understand that we have different cutoff marks for different categories, wherein the provision of different cutoff marks also has a constitutional legitimacy because it is mentioned under Article 335. Clear? Okay. So this was Article 16 clause 4 and 335, the combination. Lastly, and very important, quotas should be confined to initial recruitment only. Supreme Court said that quota, reservation, affirmative action, special provision. I am saying this again and again and again. They all mean the same thing. They are synonyms, right? Paryayavachi for those from the Hindi belt. And I hope you will understand this word, right? Because I see some people saying quota. What is quota? What is affirmative action? They all mean the same thing. Affirmative action was a word coined by the former US President John F. Kennedy. It means the same thing, providing reservation. Anyway, so quota should be limited to initial recruitment. And this is where the uh, biggest heartburn comes. That a lot of people say that once the quota has been given in recruitment, then no reservation should be given in promotion. So basically, Supreme Court said no reservation in promotion. But one more thing, what is your opinion? Should we have reservation in promotion? Because once you have given reservation in the entry, you have given equality of opportunity. Then should we have reservation in promotions? Supreme Court made the judgment. The Parliament modified the constitution Article 16 clause 4A was added. This article is meant for reservation in promotion, right? So for scheduled castes and scheduled tribes, let me clarify, not for SEBCs, but for scheduled castes and scheduled tribes, there is reservation in promotion. There exists reservation in promotion for these communities, not for socially and educationally backward communities. Clear? Now, somebody would say, why? Once we are giving reservation, then why in promotion? I'll give you an example. In 2019, out of 82 Government of India secretaries, and one more thing, I think you have understood by now that the reservation is around 60%, 59.5% seats are reserved for all the categories except the PWDs, except them. So if you randomly, if we find that every 100 people who enter the system, for every 100 people who enter the system, almost 15 should be scheduled castes, 7 or 8 will be scheduled tribes, 27 will be OBCs. So roughly of every 100 people at every level in the government jobs, 20 to 23 will be scheduled castes and scheduled tribes. It was found that out of 82 topmost IAS officers, Government of India secretaries, 4 belong to scheduled caste or scheduled tribe, not, I mean, total. Then, out of 457 secretaries, additional secretaries, joint secretaries, only 12% belong to scheduled castes or OBCs, which should be roughly 42%. If we have such equality in promotions, then how is this happening? Now you may say, sir, or maybe these people are not at the same merit level. Okay, fair enough. Let's take that. Incompetent people. Very good, very good. This is where the lack of knowledge comes into picture. How are people promoted? Based on their annual performance report, the appraisal report. Are you aware that in our country, there are civil servants getting gradings of performance, outstanding performance, good performance, and poor performance? How many civil servants get an outstanding performance in their annual report? How many? Tell me. 10%, 20%, 30%? Can you read what I have written here? 98% outstanding performance. Okay? So please don't mention the word incompetency, because as per what, 98%? Are you sleeping or what? 98% civil servants are declared to be performing outstandingly well. Then where is the incompetency? Then how has this happened? Are you getting the flaw in your own argument now? The problem is that there has been a systemic denial in promotions. Not just at the top, even at the middle management level. Even at the middle management level, there has been a systemic denial. That is why I gave data for middle management also, joint secretaries also. Because some of you may say, but sir, at the top, maybe age factor comes into play, etc. Joint secretary also. Age factor. See, there has been a denial. Systemic issues exist. Lot of issues like this exist where people who from a very set background come into the system, and they may hold a grudge against certain communities, and yes, it does reflect. Just like patriarchy prevails even till date, you may not follow the grudge, you may not hold the grudge, but others do, right? So, my reference to the existing patriarchy in the country, existing caste atrocities are not directed towards you per se, but towards people in general, the reports of which we see on a regular basis, right? So, and people say, if discrimination is happening, how can we not know? See, that's the beauty of discrimination. I think women here will understand it better. So, women always make this claim that whenever we go out on the road, people stare at us in a very weird fashion, making us uncomfortable. As a man, we may claim that yes, yes, we understand, we empathize. We cannot. We have never faced that kind of weirdness. So truly, you can never understand what they are going through. Only a woman would understand that very weird stare, etc. Similarly, only a man who belongs to this community, a woman who belongs to this community will truly understand those subtle ways of discrimination that people present towards them. Everybody is eating in the canteen, sharing tiffin, food from each other's tiffin. Nobody takes anything from the SC person's tiffin. Do you think he's a fool? He doesn't understand it. He understands it. When you serve tea in a cup for the SC person, a different kind of cup. They understand it. Please. So, this is with respect to the reservation in promotion. Anyway, so as I said, when it comes to the reservation for scheduled castes and scheduled tribes, it all boils down to the same old logic: historic injustice. For a lot of you, it may be a difficult thing to understand because if you don't belong to the community, of course, it would be a challenging thing to understand it. And for a lot of you who live in urban areas, cities, etc., you have largely never seen that happening around you also. So we tend to understand, and we tend to view the society as we see things around us. Limited knowledge, right? The frog in a pond situation. That's okay, no problem. But data proves otherwise. Anyway, so this was the reservation in promotion. Now, coming to the same reservation in promotion. So, what happened in 2006 was Supreme Court said that, see, government, we had given a judgment that don't make reservation in promotion, but you have made a change. No problem. Provide reservation in promotion for SC/STs, but some parameters have to be laid down. What parameters? Number one, firstly, if you want to provide reservation to any SC or ST person in promotion, you ask them to prove how they are facing backwardness, how they are still being discriminated against. Meaning, the Supreme Court said, let's do one thing: all SC people always carry a video camera and start recording everything. You cannot always prove backwardness. You cannot always find out these things. They exist in very subtle ways, right? Imagine you ask women, if you are making any claim, where are the facts? Video record everything. Carry a camera like a YouTuber around. So these are such pathetic statements made by the courts, sometimes without any empathy and understanding. Anyway, the other criteria again they re-emphasized on the same thing. What is the effect on administrative efficiency due to reservation in promotion? The administrative efficiency should not be compromised. Without any way to assess the administrative efficiency, they use this phrase over and over and over again without any categorical definition of how is the administrative efficiency being compromised. But anyway, that's it. This criteria is justified. Second one, cadre wise representation of SC/ST in government departments. See, the idea of reservation is based on inadequacy. If scheduled caste people are 15% in the total population, if OBCs are say 30, 40 or 50% in total population, then in government jobs also at least that should be the ratio in which the people should be represented. If they are less than that, it is called inadequacy. Okay, so this is a very good criteria that if you want to provide reservation in promotion, please find out whether the SC/STs are actually underrepresented or not. If let's say from SP you want to promote to SSP or DIG, you already have sufficient number of SC persons as SSP or DIG, then there is no need to provide reservation in promotion. Simple, clear. So don't overdo it also. So this was a very very valid criteria given by Supreme Court. Anyway, again this judgment was challenged, cases going on. Finally, in the Jarnail Singh judgment, Supreme Court better sense prevailed in them. They cancelled this criteria. So this has now been removed by Supreme Court in 2018. Supreme Court now says there is no need to prove your backwardness. We understand it. It's okay. But Supreme Court brought a very unique concept, a creamy layer kind of concept in the reservation in promotion. I'll explain this. Please follow carefully. Let us say there are some scheduled tribe communities, STs, two communities. One is Topo, the other is Oraon. Just like you have various caste names, surnames, similarly, amongst scheduled tribes, there are various communities. So one such community is Topo, the other is Oraon. Example, those not in states like say Jharkhand, Chhattisgarh, etc., would not have heard of such communities. But these are communities, just like you have various titles or surnames in your own religion. Now, these two people are both currently, let us assume, they are under secretaries, IAS officers. They are looking for promotion. Next level is a deputy secretary. Now, when you want to give promotion to these two people, find out amongst all the deputy secretaries how many topos and how many oraons are there. If you find that there are 7 topos and 2 oraons who are deputy secretaries, then which community will you give promotion to? Tell me. If you find that there exist 7 deputy secretaries who are topos and only 2 are oraons, then which person should get the benefit? Of course, the oraons should get the benefit. Why? Because this person is, or his community is, under represented. Are we clear, everyone? Everybody mentioning the right answer except a few. So this is the new concept of creamy layer exclusion. If my community has been sufficiently represented, then I will not get the benefit. Somebody else will get the benefit. Okay, that's it. So this is the Jarnail Singh judgment, which summarizes the reservation in promotion. Lastly, let me also tell you, in the Mukesh Kumar judgment and earlier also, Supreme Court has clarified one thing, and for all of you to know, reservation is not a fundamental right. Reservation is an exception. What is a right? Right is no discrimination. That is your right. But reservation is an exception. Reservation is a positive discrimination. Reservation is an enabling provision. It is not a fundamental right. You can't claim it in court. Neither Article 16 Clause 4 nor Article 16 Clause 4A. What is 4A? Tell me. This is in promotion. Clear? That's it. Supreme Court said that state is not bound to make reservation for SCs, STs in matters of promotion. Now, if they want to, they can, but for that, please collect quantifiable data. Data must be collected to prove that the community is not sufficiently represented. Don't make random reservations. Are we clear on this? This is the biggest challenge, that the governments treat this not as upliftment but as vote bank politics. That's a sad story in the country. And reservation has received a lot of no, backlash, also because even those people who understood and accepted this as a very important element, they were surprised by some of our great politicians' statements on reservation. I don't want to quote the names of the leaders, but I'll tell you the statement. There used to be a slogan doing the rounds when the Mandal Commission report was implemented. Mandal versus Kamandal. So Kamandal is a reference to the Brahmins carrying a pot, a vessel, Kamandal, which has the holy water of Ganga, sorry, Ganges, as we say now. So holy water of Ganga was there in the Kamandal. So Kamandal, Brahmins, Mandal is a response to Kamandal. No, it is not a response to anything. Reservation is not a response to anything. Reservation is affirmative actions. Some provisions provided to people to ensure that the starting line is the same. That's it. It is not some revenge. Or a very popular leader made a public statement once that till for generations our women were working in the fields under these upper caste people being harassed. Now the time has come for their women to go out and work. What kind of statement is this? What is this harassment of women, etc.? Reservation is not revenge. You are ensuring social empowerment of people. So this mentality of our politicians, also depraved mentality, has also led to a lot of problems with respect to reservation and being seen in a very negative light. And of course, name one policy in the country which is not being cornered by rich and elite people. Reservation is also such a policy where you will find that it is being misused by people who are not deserving. That does not mean the policy is wrong. The government has to take steps to provide for better implementation of the policy. Right? That's it. That's all as far as the Article 16 reservation is concerned. This is again the EWS category reservation, the economically weaker section in government jobs. We already know it. Supreme Court recently has upheld this as constitutionally valid. Clear? That's it. So that's all as far as Article 16 is concerned. We are done with the reservation policy in the country. Don't expect a mains based question to be asked on this. It's a very emotive topic, a very emotional topic, a divisive topic. UPSC generally refrains from asking such questions. But in the prelims this time, they did ask a question. For the first time from this kind of topic, a question was asked. Though nothing controversial, but information based topic question. Factual question was asked. Please solve this question. Of course, it's an easy question, frankly, because second statement is wrong. Article 335 defines. That's in general, it is more likely to be a wrong statement because our constitution rarely defines anything. So there is no definition of what is the meaning of efficiency of administration, right? So this is wrong. This means this is wrong, this is wrong, this is wrong. C has to be the right answer. Let's see. The Supreme Court of India has held in some judgments like Indira Sani case and all that the reservation policies made under Article 16 Clause 4 would be limited by Article 335 for the maintenance of efficiency of administration. This is a correct statement. Correct statement. Okay. Uh, Please remember everything that has been taught in the class. No selective information. It's all important. What is an expected question in 2024? Please read everything. Don't fall prey to all this. This is not your school examination. What is Article 335? Don't make such statements. Article 335. We just saw it. Okay. That's the beauty of our innocent aspirants. They never fail to surprise you. Uh, Mains based question from this, that may not be asked because it would require you to reveal your stand on reservation, which the UPSC itself may not be open to accepting. Okay, because they know that you may not have a very unbiased opinion since you are embroiled in this. Okay, moving on to Article 17, abolition of untouchability. Now, one small point, some of you may believe because of the wrong use of words in the books also, that Article 17 is absolute. Of course. But Article 17 is not a fundamental right in its essence. This is actually restriction on people, abolition of untouchability. So, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability, any kind of disability, if you enforce on the basis of untouchability, is going to be punishable in accordance with law. Clear? So, untouchability per se is abolished. And if you try to practice it, we can punish you through a law. Now, the point is, what is this law? Where is the law? There is no law. The Constitution says that yes, this is wrong, you'll be punished. But what is the punishment? Where is the law? The Article 17 leaves the law making part for the parliament. And you make the law in future. So such kind of articles which are incomplete, which leave lot of room for parliament to also perform, these are called non self executory articles. Why are they non self executory? Because on its own, this has no meaning. What's the point? You say untouchability is wrong, it is punishable. But if somebody practices untouchability, what is the punishment? What is the procedure? You have to mention all these things. So it requires proper mention separately. So this article in itself cannot be executed fully without the parliament's interference and a law being made. Clear? Non self executory. So this is very common because see, the point of rights was to give people rights and restrictions. Going into details and all, that was not possible. That is why this provision is there. You will find this in various places. Okay, nothing unique here. So, what's the definition of untouchability? Now, untouchability, this word is not defined anywhere in the constitution. Not defined in the constitution. But we can arrive at a very generic kind of definition that a practice largely amongst Hindus, which looks down upon members of certain classes solely on account of their birth. A very loose definition of untouchability can be this. There are some international examples also. For example, there used to exist and still does a community of cagots, toddy makers, toddy, local desi liquor maker. Okay, these cagots are in western France, northern part of Spain. You will find these communities. They have been facing a similar kind of untouchability. Okay, or you have these Ragyapas in Tibet, faced a similar kind of untouchability. Or Burakumins in Japan, similar kind of untouchability. Okay, Bike Jeongs in Korea, various communities. Now, as we these are names of communities. Like in your country, you have a Brahmin, Kshatriya, Vaishya, Shudra. Similarly, in these countries, these are also names of certain communities. Anyway, when it comes to this particular, in accordance with law, where is the law? The parliament was expected to make a law, and parliament has made a law. That law is called PCRA, Protection of Civil Rights Act 1955. This law was originally called Untouchability Offences Act of 1955, but now called Protection of Civil Rights Act 1955. It was renamed. In 1976. Now, this PCRA prescribes punishments for preaching or practicing untouchability. What are the offenses under this act? What all things are considered to be offenses? Number one, enforcing any religious disability. Number two, enforcing any social disability. Number three, refusing to admit persons to hospitals, etc. refusing to sell goods to SC, ST, scheduled caste people, inciting or encouraging the practice of untouchability. All these things are considered to be offenses. What is a religious disability? If you deny entry of an SC person in the temple, that is called enforcing a religious disability, preventing entry in a place of worship. What is a social disability? If you say you are SC person, you can't be a priest, you are SC person, you can't open this kind of shop. So that is also enforcing social disabilities. When you prevent an SC person from practicing a profession, an occupation, a trade, a business of their choice. Others are easy to understand. Now, what is a punishment under PCRA? The punishment is, of course, 6 months of jail or fine of huge amount of 500 rupees or both. For repeat offenders, 2 years or 2000 rupees in fine. And next point, please tell me, where have we seen this provision? I want the exact law, exact section, exact subsection. So far, two people, Kirtana and Funny, have mentioned the subsection also. Some of you are saying no, never seen only. So sweet, so nice. Okay, this is as per section 8, subsection 1 of RPA 1951. Don't write 8A, etc. Please. 8A is a different section only, altogether. This is not correct. Right? When I ask questions, it's all wrong answers and silence. Otherwise, I keep on getting bombarded with questions only. How is it justified? Sit at home and revise. Please understand this point. Revision is important, right? It is disappointing to see this kind of response. I had said very clearly in the chapter elections under RPA that this section is important, mug up all the sections and subsections. Still, this is a response. Not justified. I mean, how can you, sleep at night, I would say, peacefully, knowing that you have fully and properly studied, cheating yourselves and feeling happy about it? Pride. Just because nobody scolds you, you have just gotten out of hand. That's the whole point. No command of parents over some of you. I clearly can see that through the statements you make. Shameful. And the aspirations of being an IAS officer with basic information missing, right? Anyway, so this disqualification is there for RP. If you remember, let me just remind you that there are some laws. If you break those laws, what happens is that the moment the court finds you guilty, you are disqualified for the jail term if you are given any plus 6 more years. That is the section 8(1) of RPA. So a very important element is that if you are charged and found guilty by court, no post of MP, MLA, MLC for you. Okay, that's it. Now, one very interesting thing. Sachin, sir, sir, Sachin, you please give your own response. Don't talk on behalf of other students. One more thing. Normally, I think you have heard this term everywhere. Innocent till proven guilty. That's what all our politicians also say. Court has not found me guilty. So you are innocent till you are proven guilty. Yes or no? Every law has the exact same situation, except this law. This law operates on the presumption of guilt. If a case is filed against you, you are presumed to be guilty. You are guilty. You please prove that you have not practiced untouchability. Such is the harshness of the law. To ensure that it is not misused, nobody dare practice untouchability. The court works on the presumption that you are guilty. It is assumed that you are guilty. You please prove otherwise. Very strict, right? And the offense is cognizable. So normally, when you a case is filed against you, the police collects some evidence and gets the permission from the magistrate to arrest you. Warrant, right? Arrest warrant has come. Here, the offense is cognizable, where arrest without warrant is also possible. Clear on this? Secondly, one more revision time. Non-compoundable. Tell me, what is a compoundable offense? Write what is a compoundable offense and also write the topic where we saw this word compoundable offense. Okay, very good. This is, I think, a lot of you are writing it. Compoundable offenses are petty offenses, small offenses, where out of court settlement is possible under Lok Adalats. Remember, civil and compoundable criminal cases. So, compoundable means a small, petty offense, maybe chain snatching, pickpocketing, right? But practicing untouchability is a non compoundable offense. It's a heinous, a very serious offense where out of court settlement is not allowed. You cannot practice untouchability and say sorry. Okay? That will not happen. That will not be tolerated. So, PCRA 1955. On a side note, because this change happened, there's also law in the country, a different law. Now, this is a different law. This law is called the SCST, Prevention of Atrocities Act. See, PCRA is meant for scheduled caste people, but this law is meant for scheduled castes and scheduled tribes. SCST, Prevention of Atrocities Act. This law provides for preventing atrocities against scheduled castes and scheduled tribes and any relief, etc. In fact, this word atrocity is defined under the law. There is a section 3 of this law which defines what is an atrocity. It's not some generic kind of word. There are 30 different definitions of atrocities. Number one, if you force any SC/ST person to eat something obnoxious, if you dump something obnoxious in the house of SC/ST person, if you occupy SC/ST land, if you publicly humiliate an SC/ST person based on their SC/ST status, all this can result in a jail sentence from 6 months to 5 years, committing assault on SC/ST person. And not just this, hear me out carefully. If you are a public servant, of course, a non SC/ST public servant, because this law is available only for or is against only non SC/ST person. So, if an SC person commits atrocity against another SC person, they can't be punished under this law. Are they clear? This is meant for non SC/ST only. So, if you are a public servant and you belong to a non SC/ST group, community, and you fail to perform your duties towards a scheduled caste or a scheduled tribe person, you can be jailed from 6 months to 1 year. Are you clear? Not just this. If you ever give any false evidence in court against an SC/ST person, and because of that false evidence, the SC or ST person got life imprisonment or got death sentence, you may also be given life imprisonment. You may also be given death sentence. Clear? Such is the strictness of this law. Extremely strict. Apart from this, this law also provides for all the same things, meaning no need for any kind of FIR, direct arrests, no need for any inquiry, direct arrest of people. So in 2018, a petition was filed that this law is being misused. So Supreme Court, a two-judge bench, gave a judgment that there should not be automatic registration of FIR. Okay. Firstly, please, the police officer concerned, conduct a basic inquiry. A preliminary inquiry must be conducted. So whenever you go and complain to the police that robbery has happened in my house, police won't register your complaint directly and file an FIR, start investigations. Police will firstly conduct inquiry. You say, uh, uh, in my house, I had a Rolls Royce Phantom. It is stolen. Please. The police will say, looking at you, there is no scope of you having a Rolls Royce. Forget Rolls Royce. Do you have a cycle also? So, come on. Police has to firstly conduct inquiries. Whether your complaint is true or not. You can claim tomorrow that in my house I had 20 crore rupees. It's stolen from somewhere. Give me 20 crores. How can I give 20 crores to you? So, a very generic thing is firstly conduct inquiry to ascertain whether your complaint is actually genuine or not. But in these cases, it was not happening. So, Supreme Court said basic inquiry must be conducted. And if you want to arrest somebody, you have to take the written permission from a gazetted officer, a DSP, or an SP in that case. But when this judgment came, the Subhash Mahajan case, there was a lot of hue and cry in the public. Public became very angry. A lot of SC/STs came to Delhi to protest. So the government modified the law, amended the law, added section 18A to go back to the old provisions. Original provisions were restored. Original provisions were restored. So we are back to the original provisions. In fact, later on, next year in 2019, in the month of October, a three-judge bench cancelled the earlier judgment saying the judgment is wrong, the government's amendment is right, and now we are back to the same situation where there is no need of inquiry, direct arrests are possible. Are we clear on this? The Subhash Mahajan case judgment has been sidelined, has been set aside by the Supreme Court itself. Okay. Solve this question. Easy question. I'll give 30 seconds, not 45 seconds. Why did you mark right against exploitation? We have not even studied exploitation. Right against exploitation is Article 23 and 24. What is this daydreaming happening here? I am not sure. We are still studying Articles 14 to 18, right to equality. Do you remember this? Untouchability is Article 17, a part of right to equality. Then comes right to freedom. Then comes exploitation, not right to, right against. Why have you marking all these things? D is the right answer. Focus, focus. And the last article under right to equality is abolition of titles. Again, to ensure equality, we know very well that if you give titles, especially in the British Indian times, Britishers used to give titles. Rai Bahadur, Company Bahadur, all these things are not applicable now. No title, of course, except a military one or an academic one. No title will be conferred by the state. Sorry, state will not give you any kind of title. Of course, if it's a military title or an educational title, doctor, etc., then yes, allowed. Otherwise, no. So you won't call you the pride of the nation, etc. Rai Bahadur, Company Bahadur, Sir. Like we have the knighthood in UK. We don't do all these things. One simple question: based on your behavior, based on your parameters, etc., whatever, can Byju's start giving you title King of Byju's, Queen of Byju's? Tell me, can Byju start giving title like this? No. Why are you writing no? No title shall be conferred by the state. What is state? Article 12. Did you forget it? State will not give titles. Byju's can give any kind of title. Nobody cares. Nobody is bothered. The state should not give title. That creates discrimination. Are we clear? If this was the case, then all your loved ones calling you Babu, Shona, all these things, those are titles only. Yes or no? Don't worry. You are free to use those things. Keep using them. Those cringe-worthy things, limit it to yourself only. Free. No problem. Okay? Now, second thing, no citizen of India shall accept any title from a foreign state. So, a foreign state will not give a title to an Indian citizen. So, ideally, now there is no law, no rule to implement it, but the provision is very clear. There is a law, Article 18, Clause 2, that an Indian citizen will not accept a title from a foreign country. Why? It will violate Article 18. If you do it, you may lose Indian citizenship. How and why? We don't know. Nothing is mentioned. But a title will not be given to any Indian citizen. Number three, if any foreigner, if any foreigner comes to India and is holding some office of profit, getting some money from the government for some contract, business, etc., whatever, while holding that office of profit, if he tries to get any title from a foreign state, he or she has to take the prior permission from the president. Okay. Now, lastly, no person, this is for people like you, if you are holding any office of profit or trust, then you also have to get the consent of the president in case any foreign state tries to give you any present, any gift, any post. Are we clear on this? So, all those foreign officers from here, right? IFS officers, when you are posted in some foreign country, don't jump and take all the gifts that you receive. Are we clear on this? Bhagya, what is Office of Profit? Great. After 2 days, ask me what is the president. Refer to your chapter parliament, you will find out Office of Profit. So, all those people, future aspirants or future officers, please have the decency. Don't jump and accept all the gifts. They are gifts not meant for you, meant for the post. Clear? So please deposit those gifts in the government treasury. Don't take them home. Anyway, for all those people who are IFS officers, you cannot marry a foreigner also. Let me just clarify. Without the permission of the Indian president, you are not allowed to marry a foreigner. So you can marry a foreigner. Don't lose hope. Possible. Oh, somebody is very sad. Why this is happening? You can marry. Firstly, get a foreigner to marry you, and then we'll discuss why not. So, marry a foreigner, but with the permission of the Indian president. Okay. Then how has somebody gotten married? Because the Indian president allowed. That's what I'm saying. Hear me out first before showcasing the half baked knowledge. That you need the approval of the president, not your parents. Look at the elevation of status in your life. Right now, you are struggling to convince your parents. After the exam is cleared, you will convince the president of India. Today's motivation. Okay? Okay. Now, moving on to just a small point, National Civil Awards. So, there has been a lot of controversy around the National Civil Awards, the Padma Shri, Padma Bhushan, Padma Bhushan, and Bharat Ratna. These awards were started by Nehru in 1954, though in 1977, when Janata Party came to power, they removed these awards. They said these awards create inequality in the country. Why is somebody called Bharat Ratna? What are others? Stones of Bharat. Useless people. Why only some people are called Bharat Ratna? So they are very angry at this. They said, no, all these awards, they create a divide in the country. Again in 1992, it was suspended because it was challenged in the High Court that these awards are titles. But the court has said that these national awards, they are not titles. Every country has full right and authority to, bestow some recognition to its performing citizens, contributing citizens. Look at the criteria of getting this award. You will get a Padma Shri if you have performed distinguished service. What is the meaning of this? We don't know. You will get Padma Bhushan if you have performed distinguished service of a high order. Padma Bhushan if you have performed exceptional and distinguished service. And Bharat Ratna if you have performed exceptional service or the performance of highest order only. These are given by Government of India. So I think now we can know what is the meaning of distinguished service. If you praise the government a bit, Padma Shri. If you praise the government regularly, Bhushan. If you are really in love with the government, Padma Bhushan. If you are a crazy fan of government, then Bharat Ratna. I mean, that is what is the perception here, sadly. Now, one more thing. National Civil Awards, if you are bestowed upon these awards, you can't use these awards in your name. If you get this award, Padma Shri, don't go to Aadhaar office saying, Aadhaar office, please change my name. Now my name is Padma Shri ABC. You can't do that. If you are found doing this, your award will be taken away from you. So, can't be used in the name. Now, this Padma Shri, Padma Bhushan, Padma Bhushan, there is no limit to how many you can give. But for Bharat Ratna, there's a limit. Maximum 3 per year. Though there was an exception. Exception is you will find 1999. In 1999, four people were given this award, but that was an exception. Normally, only three. Okay, that's it. One small problem. If you remember, in 1954, these awards were started, and this award was given for the first time in 1954 by the government of India only, the Prime Minister. In 1955, who was the Prime Minister? Tell me. In 1955, quickly, don't waste time. Who was the PM of India? Pandit Nehru. Great. Very good. Lal Bahadur? Sir, it's okay. Pandit Nehru was the Prime Minister. Sorry for asking this question. In 1955, Pandit Nehru got the Bharat Ratna. He was a Prime Minister and he got the Bharat Ratna. It was published in the media that the cabinet is forcing, sir, you please take the award. He's saying, no, 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 I don't want the award, please. So he was forced into accepting the award. Yeah, really, of course. A similar situation happened in 1917 also. In 1971, tell me please, who was the Prime Minister of the country? Please tell me. Indira Gandhi. In 1971, Indira Gandhi got the Bharat Ratna. She said, if my papa can do it, I can do it. I mean, they are giving the award to themselves only. Come on. And some people like Patel, Ambedkar, they had to wait for 40 years. You'll be surprised to know that Patel, Sardar Patel, got this Bharat Ratna in 1991. Dr. Ambedkar, the chairman of the drafting committee, and Rajiv Gandhi, they shared the award in the year 1990. How is it fair? Do you think Ambedkar and Rajiv Gandhi's contribution was the same? Is it justified? This is a problem. The problem is that the criteria is very poor and it's the government which gives the award. Shivani, the awards are given by President in Rashtrapati Bhavan. We have all seen the function. Nothing special there. But did you remember Article 74 before making this statement? Do you think the President has the power to do all these things? Or is it under the advice of the Council of Ministers? What do we feel? Some emotional aspirant says that the President is giving all these awards, not the Prime Minister. Again, we have to remind the person that it's Article 74. So, one suggestion is that when it comes to these awards, two things. Please fix a criteria. This kind of vague criteria, what is this? Distinguished service and all? Defined criteria. Number two. One more thing. See, now, for example, in 2014, we gave this award to Sachin Tendulkar. Do you think now should we give this award to Bhagat Singh? Is it justified? Or Dhyan Chand? Justified? I mean, once you have given the award to a certain person, and when you give the award to other person after that person, you are only putting the person at a lower platform and pedestal. That's not justified. And now, see, giving the award to Subhash Chandra Bose, Bhagat Singh, they don't need this award. It's okay. Some people are bigger than these awards. They are not dependent on our showering of respect based on some political situation. So it's okay. No problem. I mean, in 1990, if Ambedkar was not given the award, it was okay. It's okay. No problem. Just because he don't get the award does not mean his contribution is any less. if you equate these two people, you're only undermining Ambedkar's contribution. That's the sad part. So we should not confer this award on past personalities. Stop conferring the awards on past personalities, right? So it is very, very important to follow a proper hierarchy. Otherwise, perversion of hierarchy takes place. So we should follow some suggestions here. But of course, we know that this is Rajiv Gandhi, not MK Gandhi. So this kind of criteria should be followed ideally. Okay, that's it. We are done with right to equality, articles 14 to 18. Very important. Mug up all the provisions. What has been taught in the slides, extremely important. Don't skip any information. Before we end, solve one question for the day. Last question for the day. And then we'll show the leaderboard of how the performance was today. Beautiful. Excellent. Fantastic. Not correct. Did we see not correct? Bharat Ratna and Padma Awards are titles, yes or no? No, they are not titles. Padma Awards, which were instituted in 1954, were suspended only once? No, twice. And the number of these awards is restricted to maximum 5 or 3? 3. All 3 are wrong. D is the right answer. 1, 2, and 3. Let's see the leaderboard. Only 2 people remain at top, Janvi and Lucky. Then one at number 3, Shelly. Others follow, Siddharth, Kirtana, Sumant, Naveen, Shamil, Raj, Rishabh, Sat, Meera, Deepesh, Ankush, Himanshu. Then we have Himanshu, Tejinder, etc. That's it. We are done with our discussion for the day. Interestingly, I never find all these people here asking questions, too many questions. And those who are asking too many questions, I don't find their names here, barring a few. How is this happening? Uh, I hope you have been following the Yojana Kurukshetra, right? Yojana Kurukshetra, political theory, revision number 3 should have started by now. Monthly magazine, the month of June. Did we start? We should be starting right now. Today, the PPT is very important. Please mug up the PPTs. And of course, without failure, read the editorials. Okay. Today's question is really tough. Not really tough here. I mean, it's okay. Maybe lack of revisions. Vivek, I'm in class. But when I asked school, you did not mention you were in class 12th. Vivek, ignore it. Don't read Yojana Kurukshetra. Arjun, watch the videos that are there available. No, no, there is some other Vivek. There are two Viveks, one with some image of the national emblem. That Vivek, who is in class 12th. Common names create a confusion. Anjali, sir, if Article 15 to 18 speak language of right to equality, then why it is not included in Article 14? There are different types of equality. That is why the entire group, 14 to 18, are right to equality. Mug up all the topics, Surta. Sonam, these awards were suspended two times in 1977 and 1992. Yes, Bhavya, avoid. Mosques don't allow Hindus. Really? Not in general. Maybe some mosques. I'm not sure, but not in general. And as I said, please do not involve religion right now because we need to know Article 26 also. Very, very important. Right now, we have lack of information to make an informed statement. How to make this is notes only. Why are you making your own notes separately? These are notes only. That is why when you sit in the class and just sleep, half sleep, either make notes there only, like you do in your normal school days and college days, or these are notes sufficient for you to revise later on. Don't duplicate the effort. Chandra Jyoti, gap of more than 30-35 days should not happen. So the cycle should repeat for every subject every 30 days. Janvi, that can be done definitely. But the problem is that it is a very difficult tool to implement. And no political party will show any kind of interest in doing such things. Gauri, mail. Don't worry. Mails. Till you clear the examination. Even after that, no problem. They don't show the real income. What is this? Random statement from Arjun. Arjun, Janvi's statement was for SC STs. Ignore that. J. Subhashini, sir, can we read NCERT along these classes? Yes, we can. It is possible. That's why I'm telling you to read political theory on a daily basis. Yes, Abhishek, that's also okay. No problem. Whatever helps you remember things. The crux is remembering the provisions. EWS 8 lakh criteria. Yes, I mean, that's true. I mean, the we know very well how easy it is to get a income certificate in the country. So why to discuss that? No, Maruti. In fact, I'll tell you something very interesting. Once we study Article 26 on what is Supreme Court's approach towards untouchability, it is nothing short of I don't know, hilarious. Okay, that's it for today, guys. Your experts will keep on addressing your concerns. Please revise and let's meet tomorrow. Till then, that's all for me, guys. Jai Hind.